State versus Noll. It's 250096. For the appellant, Mr. Noll, we have Katie Sears. And for the appellee, State of Iowa, we have Olivia Brooks. Ms. Sears, whenever you're ready.
May it please the court? My name is Katie Sears, and I'm representing the appellant, Mr. Richard Noll. This case presents two significant constitutional questions. First, Deputy Walker performed an illegal pat-down of Mr. Noll. That pat-down was illegal because Deputy Walker did not have reasonable suspicion that Mr. Noll was presently armed and dangerous. He never claimed he suspected that. There's no evidence supporting that, so he wasn't allowed to do that. The pat-down was quick, but it still measurably extended the duration of the stop. And officers don't get free time during traffic stops to conduct unlawful pat-downs. Under Rodriguez and Arrieta, any extension of the stop is unconstitutional unless it's independently justified by reasonable suspicion that would justify expanding the scope of the stop. Second, Deputy Walker later searched Mr. Noll's person a second time. It was during that second, more intrusive search that he found the methamphetamine underlying the conviction in this case. And the state now seeks to justify that search as incident to arrest. But at the time of the search, Deputy Walker had not arrested and was not in the process of arresting Mr. Noll for anything.
Our first decision in this case on the remand, limiting the court to determining whether it was a search incident to arrest, or could the court have examined that search under other exceptions to the warrant requirement?
I'm not sure what the court intended. I suppose had the district court been so inclined, they could have expanded and explained their ruling on other grounds. I don't think they explored that really.
But the district court on the remand looked just at the search incident to arrest exception?
Yes. So a search incident to arrest is dependent first on an actual valid custodial arrest. And as State v. Stevens favorably quoted a Maryland case, Wallace v. State, probable cause to believe that a person is carrying evidence does not justify a warrantless search of the person, any more than probable cause to believe a house contains evidence justifies a warrantless search of the house. At its core, the state's argument appears to be that officers may search whenever they have, or whenever they believe they have probable cause that could justify an arrest. That's dangerous, and it's disallowed under controlling precedent. Iowa courts have previously attempted to extend the search incident to arrest doctrine to include searches incident to citation. Under Iowa Code Section 805.1 sub 1, an officer can issue a citation in lieu of arrest anytime he has probable cause that could justify an arrest. And Section 805.1 sub 4 provides that issuing a citation does not affect the officer's authority to conduct an otherwise lawful search. So in State v. Meyer, the Iowa Supreme Court read those provisions together to allow searches incident to arrest whenever an officer issued a citation. But then the Supreme Court of the United States in Noll's held that no, that went too far. They said that Iowa cannot authorize searches incident to citation. Probable cause and a citation is not enough. So probable cause without a citation is not enough.
The state's argument today, their belief is that the deputy had probable cause to arrest Mr. Noll for operating under the influence, even if that wasn't articulated at the time of the search. Do you think the evidence the deputy had found up to that point would have justified it? There was some erratic driving, I think, driving well below the speed limit, weaving within the lane, some evidence of the Mr. Noll's response to the deputy at the scene, smell of marijuana. Was that enough to get them to the OWI arrest?
No, I absolutely don't think it was. And we cited a number of cases in our brief under which weaving in a lane, even briefly crossing onto the fog line, does not establish even reasonable suspicion, let alone probable cause. He definitely did not have any basis to believe he was under the influence of marijuana. He claimed he smelled marijuana in the truck not on Mr. Noll's person. He searched the truck, he didn't find anything. There also was no, and it came in over trial counsel's foundation objection, there was no foundation that Deputy Walker could identify the smell of marijuana. He testified that he could differentiate it from cow manure, but he didn't establish anything beyond that.
What about the fact that, as I understand, Mr. Noll was operating a motor vehicle without, or with a restricted license, requiring an ignition interlock in his car, yet when he was pulled over, there was no ignition interlock in his vehicle. Is there any notion that that in and of itself is an arrestable offense, such that why are we talking about OWI and all this? I mean, isn't that a full stop after that?
So thank you for asking. As far as I can tell, driving without an interlock when you're supposed to have an interlock could be a contempt. And I'm not super clear on whether or not an officer can make a warrantless arrest for that. Contempt proceedings are quasi-criminal. There was no warrant for that. And at any rate, he didn't arrest for that. Under section...
Wouldn't it be driving while suspended?
No, I don't believe his license was suspended.
So a restricted license provision on a license, if you're driving not in conformity with that, that wouldn't subject you to driving while suspension?
The answer to that is, I'm sorry. Either way, under section 804.14, the police officer is supposed to inform the person they're arresting of the reason for arrest. And under D-Ray, USB D-Ray, it is the officer's responsibility to know what he is arresting for and why.
So on that point, if we find that there was probable cause to arrest for OWI, but the officer, after finding the methamphetamine, told the defendant, I'm arresting you for possession of methamphetamine, how does that affect our analysis? Is your argument that the officer can't change the reason for arrest based on other evidence found after the search?
I'd like to clarify your question. Are you saying if he was, you said he had probable cause for OWI. Are you asking if he was arresting for OWI?
Say that, the cases say that if you have probable cause to arrest, right, then you can make the search, not necessarily contemporaneous with the arrest, but even, after, contemporaneous or after. So if we find that the officer had probable cause to arrest for OWI, doesn't that validate his search?
Not. So the officer has to actually be conducting an arrest for OWI. Probable cause that he is not effectuating with an arrest does not justify a search incident to arrest.
Do you have a case? Is there any case that fits within these facts where, maybe the officer had probable cause to arrest for a different offense than he actually arrested the defendant for after the search?
Well, I think the closest is going to be, Rabinowitz flat out says search incident to arrest is dependent initially on there being a valid arrest, not just probable cause. There are, Chambers v. Maroney says that only in exigent circumstances will the judgment of the police as to probable cause serve to justify a search of a person. And this is not an exigency case. And then under Noll's, if search incident to citation, and a citation requires probable cause, doesn't justify search incident to arrest, then I am not sure how you could possibly justify searching someone with probable cause without the citation.
Okay, thank you.
There's a bright line rule requiring the actual valid custodial arrest before the exception applies. And with that, if there's no further questions, I'd save any time for rebuttal.
Counsel.
May it please the court, opposing counsel. This court should affirm the district court's denial of Mr. Noll's motion to suppress. The deputy's search of Mr. Noll's person was a valid search incident to arrest, and the deputy gained no new information from his pat-down of Mr. Noll, nor did it prolong the stop beyond the mission of the stop.
Was Mr. Noll under arrest, and what was he being arrested for?
Yes, when we look at the videos of the dash cam and the body cam. The time of arrest there, I think, is the beginning of the search of his person. When we look at cases like Harvey and Bradford, they discuss that it's this clear deprivation of liberty. So the arrest there was for OWI. In that search, he then found the methamphetamine. Now, certainly to the formal arrest, what I mean by formal arrest is when the officer said, now you're under arrest and handcuffed. That too can be the arrest and the searches before that as well. But I think that when we look at the body cam and the dash cam, look at the officer's conduct, when that search began of his full person, the officer was arresting him for the OWI probable cause.
Cause for OWI when the officer did not perform any field sobriety test before making that arrest?
I think so, and I think when we look at the specific conduct that the officer observed when driving, that being, traveling well below the speed limit, crossing the center line, weaving within his lane, the late hour, that combined with his later observations of smelling marijuana and the open beer can, and as well as noticing that he was required to have the ignition interlocked but didn't have it at the time.
Search occurred, the smell of marijuana and the open beer can, our record doesn't show that those were verified as, that the beer can was currently an open container. I don't see that in the record in the testimony. And the smell of marijuana, there wasn't any marijuana found, right? So that would sort of detract from any probable cause to arrest for the OWI?
I don't believe that is correct, Your Honor. And I think looking at the beer can first, whether there was an amount of liquid or alcohol in there would be a question probative to beyond a reasonable doubt for guilt of that. We don't need to show probable cause to the same level as beyond a reasonable doubt. So the beer can in the cup holder within reach of the driver certainly is a fact that the officer can consider for operating while intoxicated.
The deputy didn't testify to any other indicia of alcohol consumption, right? Like no smell, nothing before the supposed arrest for OWI.
That's correct. I think the officer was investigating OWI likely for marijuana, but it's also possible for alcohol given the ignition interlock and the beer can. And so I think those two things, we don't have to say exactly what substance it is that we're investigating for the OWI for that probable cause to exist to arrest. So the officer believed it was alcohol, maybe it was marijuana. Both of those things would be sufficient for that probable cause finding. But to your question about the fact that there was no marijuana found in the car, we aren't looking at what the officer later learned, we're looking at what the officer knew at that time. And I don't think that we can look at the fact that nothing was found to disprove the district court's findings that the officer had no, I believe that...
Right? Like they determined that nothing was found before the search.
Yes, that's correct. And the officer, though there was no...
That basis for the OWI arrest before they searched the person, his person.
Again, I don't agree with that because I think there are plenty of circumstances where the substance could be consumed and therefore no longer present in the vehicle because...
Not testimony that they smelled it on Mr. Noll.
The smell of marijuana, the officer said, was limited to the vehicle. So although no marijuana was found physically in the vehicle, the officer did reaffirm that he did continue to smell marijuana throughout the vehicle during the search.
Counsel, just taking the OWI out of that, and maybe I'm being too hypothetical with facts that don't exist, but I mean, even if the officer had no suspicion of impairment, could he not still be arresting the defendant for the mere fact that he's operating not within the confines of his license? I mean, what's he supposed to tell him to do? Hop back in the car and drive illegally back to your house after I just caught you not having an interlock device in your car?
I certainly can understand that question and that concern, although I didn't look into whether the ignition interlock is an arrestable offense on its own. As we outlined in the state's briefing, that the visible beer can in the open container is an arrestable offense. Now, to the question about arresting for OWI, and if there was, probable cause for one offense, but then later arrested for another offense. State v. Bradford, an Iowa Supreme Court from 2000. In that case, the officer was investigating a harassment call, and he was later patted down and searched, and controlled substances were found. In Bradford, the court said that there was probable cause to arrest him for harassment, He was not charged with harassment. He was only charged with the controlled substance violation. I don't think that we're breaking new ground in talking about this substantially contemporaneous search and arrest context. There are several cases where the arrest is after the search, and the court finds that it is substantially contemporaneous, so that it is a search instant to arrest. There are also situations where, like that Bradford case that I was mentioning, where the search happens and the court finds that that search within itself is the arrest because of that substantially limited freedom of movement, and the deprivation of liberty becomes that arrest.
Effectively, though, if you listen to the tape, the deputy talks about after finding the methamphetamine that that's what he was being arrested for.
I do recall that moment in the video, and I don't think that he's saying, I'm only arresting you for this. I think that we can look at the context of that question and as a recency answer, or perhaps even the officer is saying, when he's asking, what are you arresting, or why am I being arrested, or something to the effect, and he's incredulously saying, dude, I found methamphetamine in your pocket. So I don't think that that is ruling out him also telling Mr. Noll at the window, I saw you swerving, I saw you crossing the center line.
More investigation to the standard field sobriety tests after that. So the investigation on the OWI continues.
That is correct. The field sobriety tests do happen back at the station. And though I don't want to hang my hat on this, I do think that it at least moves the needle that in the the implied consent agreement, the officer does put on there that the time of arrest is 11:40, and that's around the same time that the search of his person is happening at the scene. So for the implied consent, the arrest for the OWI in their Exhibit 2 does, in the suppression hearing, does note that that time of arrest for the OWI 2 happened at the scene.
Counsel, was there any impairment investigation prior to the search of the vehicle? Do you know what I'm asking? Questions about, when's the last time you smoked marijuana? Do you feel the effects of it? Would you mind submitting to some field sobriety tests for me? Was there anything related to that prior to the actual search of the vehicle?
Not that I can recall off the top of my head. I know there was a lot of back and forth between Mr. Noll and the officer, when the officer would say, I smell marijuana, and Mr. Noll would say, I don't use it, and the officer's like, I hear that all the time, I smell marijuana. So to the extent there was a specific question of when is the last time you used marijuana, I'm not recalling that question off the top of my head.
Here's where I'm going with that. It seems to me, at least from my review of the video, that from the inception, this is a drug interdiction investigation. That's my sense of it. And then once drugs aren't found in the car, the stop is elongated for other search purposes.
I don't think officers are limited to one investigation. And so I do think that the officer had, at minimum, reasonable suspicion to believe that there would be marijuana, and certainly probable cause to believe that there'd be marijuana in the vehicle based on the smell of marijuana. So I do agree that the officer was, to some extent, investigating a controlled substance arrest, a controlled substance issue. But I think that when we look at what the officer's testimony, too, at the motion to suppress about the manner of driving, those would be not necessarily inconsistent with a possession, but certainly more probative to an operating while intoxicated investigation.
Short time that you have left, can you respond to Mr. Noll's argument that in the proceedings below, the state argued he was arrested for possession of methamphetamine, and so that you waived your argument on appeal to say that there is probable cause to arrest for OWI?
Yes, so the state raised this argument in its first responsive briefing in the first direct appeal. The appellant did not respond to an error preservation in that regard, and the court did specifically direct the district court to address the search instant arrest question on remand. So while error preservation of a party, whether it's asserted or not, is not indicative, this court can of course find the error was not preserved or that an issue was waived on its own, even if not brought up by the party. But I think that the district court's remand to address that question in particular should quell any concern on that issue, given that that was essential to the remand.
Kind of a follow-up question on that. There's no published decisions on that DeVos line of cases as far as the state preserving error on a suppression issue. I know we have some unpublished cases from our court, but the Supreme Court hasn't spoken to that, have they?
It's my understanding as well. The state relies on the 3 cases that it cited, which is the Rave, the Bull, and I believe it was Jane's. The state asked that the court affirm the district court's denial of Mr. Noll's motion to suppress because the search was a valid incident to arrest and no evidence was found from the pat-down and it didn't prolong the mission of the stop. Thank you.
And Judge, just addressing briefly your comment about drug interdiction, if I recall correctly, Deputy Walker testified at the suppression hearing that he did not, at the time, have any training specific to drugs, narcotics, that sort of thing. So it would seem odd if he was out there specifically running drug interdiction. It was the state's burden to establish the applicability of an exception to the warrant requirement by a preponderance of the evidence. Warrantless exceptions are per se unreasonable unless they fall within a specific, narrow exception to the warrant requirement. So the search incident to arrest exception would have required them at the district court level to establish that there was a valid arrest for something. And the record does not establish that Deputy Walker was arresting Mr. Noll for anything before he searched him and found meth in his pocket. The state's claims are post hoc and speculative. It's, well, what if they could have arrested him for this? But it was their job to establish that that applied. As far as it being an OWI, I don't think he had a basis to think it was a drug OWI. Again, he had no training in drug stuff. He didn't have a basis to think it was an alcohol OWI. There was no testimony about the odor of alcohol. He didn't testify that the mumbling or the muttering, how he was talking, he believed that was consistent with intoxication or anything like that. And here, I don't think the beer can contributed to anything when the record shows that Mr. Noll affirmatively handed the can to Deputy Walker and allowed him to observe that it was empty. Beyond that, I don't think I've got anything more unless you guys have further questions. Thank you so much.
Consider State versus Noll submitted. I want to thank both counsel for your helpful arguments today and the good briefing in this case. And we will have a written decision forthcoming as quickly as we can. And that adjourns the court for the morning.